I woke up to the sound of voices in my backyard. Looking through my window, I froze in shock. A group of people in matching HOA polos were standing in my garden, hammering stakes into the ground and unrolling what looked like blueprints. A woman I'd never seen before approached me as I stormed outside. She thrust a document in my face, her voice cold and indifferent. According to Clause 17b, this land is being rezoned for community facilities. You should feel honored to contribute. I stood there, speechless. This garden had been my sanctuary for 15 years, where I grew my vegetables and raised my chickens. But they didn't stop there. They brought in a crane and installed an HOA sign right in the middle of my vegetable patch. Right then and there, I made a vow. If they wanted to play by the rules, I would play by the rules too, all the way to the end. My name is Mike, a retired agricultural engineer who's lived peacefully in this suburban neighborhood for over 20 years. I'm not one to cause trouble. I live alone, and I've poured my heart and soul into the quarter-acre plot behind my modest house. It's not just land to me. It's where I find purpose after my wife passed away 5 years ago. The HOA in our community was never particularly strict, until Karen Whitmore was elected as the new president 6 months ago. She ran on a platform of neighborhood beautification and enhancing community value. But those pleasant-sounding phrases quickly revealed themselves as excuses to invade residents' privacy and dictate how we should live. At first, it was small things. Speed limit signs placed without consultation. Then a ban on fruit trees in front yards because fallen fruit attracts pests. But now, they had their eyes on my backyard, my personal sanctuary. It's for a community recreation space, Karen had announced at the last meeting I didn't attend. A place where families can gather, children can play. We need to utilize all available space for the greater good. The morning after they invaded my yard, I marched straight to the HOA office, deed in hand. The documents clearly showed my property line extended beyond what they were claiming, and that my land was separately titled 15 years ago, before the current HOA covenant was even established. Karen sat behind her desk, not even bothering to look at my paperwork. Her smile never reached her eyes as she said, "The land may be yours, Mike, but the laws are ours. The HOA covenant gives us the right to designate spaces for community use, regardless of ownership." In the following days, I received a barrage of official-looking letters from the HOA, land clearance requirements, violation warnings, and even threats of a $5,000 fine if I didn't cooperate with community development plans. They called it a public use conversion plan, a fancy term for taking what wasn't theirs. Each morning, I'd find new survey markers moved further into my property. One afternoon, I caught 2 HOA board members photographing my chicken coop, discussing how it was unsightly and unhygienic, despite my meticulous care. At the grocery store, neighbors would avoid eye contact. Some whispered that I was standing in the way of progress. Others warned me privately that Karen had done this before in her previous neighborhood, targeting properties one by one until she controlled everything. "Just give in," my neighbor Tom advised. They bankrupted the Johnsons with legal fees when they tried to fight the pool installation last year. They thought I would back down. They expected an old man to surrender in the face of bureaucracy and pressure. What they didn't know was that before retirement, I had helped write the technical standards for land use policies in this very state. I might look like a simple gardener now, but I knew more about property law than their entire board combined. As I watched them measuring my garden beds for demolition, something inside me hardened. This wasn't just about land anymore. This was about justice. Day 4 after the HOA notice, I woke up to the sound of machinery. Looking outside, I saw workers setting up boundary markers along my garden's edge. They had brought in surveying equipment and were acting like the decision was already final. A man in a polo shirt with the HOA logo was flying a drone over my property, filming everything for community project documentation. When I approached him, he simply said, "Official HOA business, sir. Please don't interfere." I called my lawyer, Sarah, who had helped with my deed 15 years ago. She arrived within the hour, legal documents in hand, but the HOA representatives refused to speak with her. "This property is temporarily under assessment freeze for community facility evaluation," said a young man reading from a prepared statement. "All legal inquiries must be submitted in writing to the HOA board." Sarah looked troubled. "Mike, they're moving fast. This isn't normal procedure. Even HOAs need to follow proper rezoning protocols." We filed an official protest with the county board that afternoon. The clerk looked sympathetic as she stamped our paperwork, but then whispered, "Just so you know, the HOA submitted new zoning maps last week. Unless there's a legal challenge within 7 days, it automatically gets approved." I felt my stomach drop. 7 days from when? From last Thursday. So you have. She counted on her fingers. 6 days left. 6 days to fight an organization with lawyers on retainer, and most of my neighbors intimidated into silence. That evening, a group of board members parked in front of my house. They weren't subtle about watching me, taking notes as I tended to my garden. Karen herself walked by, clipboard in hand. "We're assessing compensation value," she said without being asked. "The HOA is prepared to offer you $500 for inconvenience, though legally we're not required to provide anything." $500 for 15 years of cultivation? I was incredulous. She shrugged. "It's generous, considering the covenant allows for community repurposing without compensation. You should take it before the offer expires." The next day, I found notices posted along my fence. "Future site of Whitmore Community Pavilion." They had already named it after Karen. I tried speaking at the emergency HOA meeting that night, but my microphone was cut off after 30 seconds. "Time constraints," the moderator explained, though Karen was allowed to speak for 20 minutes about her vision for neighborhood enhancement. 3 days before the deadline, they escalated further. A cease and desist letter arrived, ordering me to stop all agricultural activities on the disputed land. My chickens were now classified as livestock incompatible with residential common areas. I felt the walls closing in. My neighbors were sympathetic in private, but afraid to speak publicly. The county clerk said their hands were tied until the 7-day period passed. My lawyer was buried in HOA bylaws looking for any leverage. That night, as I sat on my porch watching the sun set over my threatened garden, my elderly neighbor Walter hobbled up my driveway. He'd lived here longer than anyone, rarely leaving his house these days. "Mike," he said, his voice gravelly from years of smoking, "you might want to look at this." He handed me a yellowed folder. It's the original HOA founding charter from 1994. There are some provisions in there, ones they never updated. I thanked him, not expecting much, but as I read through the documents that night, my pulse quickened. There it was in Section 8, Paragraph 3. A dissolution clause that could be triggered if the HOA made improper rezoning attempts twice within a 5-year period. And they had already made one such attempt last year with the community pool, which they had to abandon due to improper filing. Nobody had challenged them legally then, but the incorrect paperwork still existed in county records. I stayed up all night, making calls to former colleagues in land management, digging through public records online. By morning, I had found the legal loophole that could not just save my land, but potentially dissolve the entire HOA in 7 days. But first, I needed proof of their current violation. And for that, I needed to let them continue their overreach just a little longer. If you've ever dealt with an unreasonable HOA like this one, type "unreal" in the comments to show how many people have experienced similar injustice. With my new strategy in place, I began methodically gathering evidence. First, I pulled county records of the HOA's previous rezoning attempt from 2022, the community pool project they'd quietly abandoned after technical objections from the water department. I hired an independent surveyor, at considerable expense, to assess the markers they'd placed on my property. His official report confirmed what I suspected. Their proposed boundary encroached 12 feet beyond even what the HOA covenant could possibly claim. Next, I photographed every stake, every marker, every instance of them trespassing on my property. I recorded conversations when legal, documented every interaction, and saved every letter and email. The HOA's strategy relied on overwhelming homeowners with bureaucracy until they gave up. But they'd never faced someone who understood the system better than they did. 3 days before the county deadline, I submitted my masterstroke, a formal petition to invoke Section 8 of the original HOA charter, citing dissolution due to repeated improper zoning violations. I included the surveyor's report, county records of their previous failed attempt, and documentation of their current overreach. The county clerk's eyes widened as she reviewed my petition. "This is unusually comprehensive," she said, stamping it with an urgent processing code. Within hours, Karen and the entire HOA board received court summons for an emergency hearing. The panic was immediate. I received 3 voice messages from Karen that afternoon, her tone evolving from commanding to conciliatory to desperate. "This is all a misunderstanding," her final message pleaded. "Let's meet privately to resolve this matter." But it was too late for private meetings. The legal machinery I'd set in motion couldn't be stopped. The day of the hearing arrived. The courtroom was packed. Nearly every homeowner in our community had come to witness the showdown. Karen and the board sat with their attorney, a slick corporate lawyer who specialized in real estate development. When my turn came to present evidence, I approached steadily, carrying 15 years of property records, HOA correspondence, and the original charter with Section 8 highlighted. "Your Honor," I began, "I'm not just challenging the HOA's claim to my property. I'm demonstrating a pattern of deliberate zoning violations that, according to their own founding document, renders the entire organization legally invalid." I presented the evidence methodically: the previous improper pool rezoning, the current boundary violations, the drone footage they'd taken without permission, and the original dissolution clause they'd never bothered to amend. Karen's attorney tried to object. "This is an outdated provision that hasn't been enforced in decades." The judge peered over her glasses. "Has it been formally removed from the charter?" "Well, no, but then it remains in effect," the judge stated firmly. When Karen took the stand, she attempted to portray the community pavilion as a benevolent project. "We're simply trying to provide amenities for families," she insisted. "And you chose Mr. Sullivan's property specifically because," the judge asked. "It was the most suitable location for community needs," Karen replied. That's when my lawyer presented the final piece of evidence: email correspondence between Karen and a commercial developer discussing how the community pavilion could later be rezoned for commercial use, potentially increasing property values for board members who owned adjacent lots. The courtroom erupted. Neighbors who had been silent for months suddenly found their voices, shouting questions and accusations. The judge had to bang her gavel repeatedly for order. After 2 hours of testimony, the judge delivered her ruling. The HOA had indeed violated its own charter through improper zoning actions twice within the specified period. According to Section 8, this triggered automatic dissolution of the organization and termination of all its enforcement powers. The Whispering Pines Homeowners Association is hereby dissolved. Effective immediately, the judge declared, all property restrictions imposed solely by HOA covenant, not otherwise covered by county regulations, are nullified. Karen's face drained of color as the implications sank in. Not only had she lost control of my land, she had lost the entire HOA and her position of power. As we filed out of the courtroom, neighbors I barely knew approached me with handshakes, hugs, and tears. 4 families who had faced similar threats from the HOA brought beer and cake to my house that evening for an impromptu celebration. We wanted to fight back, but were too scared, admitted Jennifer, who had nearly lost her disability ramp to HOA regulations. You did what none of us had the courage to do. I realized then that standing up hadn't just been about protecting my garden. It had been about liberating an entire neighborhood from rules that had grown increasingly arbitrary and oppressive. 1 week after the judge's ruling, the HOA signs throughout the neighborhood came down. The pretentious Whispering Pines Estates placard at our entrance was replaced with the simple Whispering Pines, name the community had used for decades before Karen's rebranding. The mandatory HOA fees, which had mysteriously increased by 40% under Karen's leadership, were discontinued. Many residents found themselves with extra money for the first time in years. Some used it for home improvements they'd previously been unable to afford. Karen resigned from the neighborhood board, what was left of it, and put her house on the market within days. No one has heard from her since, though rumors suggest she moved to another planned community across town. I imagine she's already running for board president there. As for my contested land, I decided to do something unexpected. I expanded my garden and built a small Japanese-inspired meditation space open to all neighbors. Next to it, I installed a free little library filled with books on gardening, nature, and community building. No mandatory community use designation was needed. People came because they wanted to, not because they were forced to. Children began stopping by after school to collect fresh eggs from my chickens. Elderly neighbors found peace sitting under the maple tree. The land that was nearly taken from me has become something genuinely communal, through cooperation rather than coercion. Those who had once avoided eye contact now bring homemade dishes to share during impromptu garden gatherings. The neighbors who had been silenced by fear now speak freely about improvements they'd like to see in our community. We've formed a voluntary neighborhood association, one with no enforcement powers, no mandatory fees, and rotating leadership. We make decisions by consensus, rather than by the dictates of a single board president. Some neighbors have nicknamed me the Quiet Lawyer Killer, though I'm neither quiet nor a lawyer. I'm just someone who refused to be bullied and who knew exactly which page of the rulebook to turn to. Last month, I received a letter from a neighborhood across town facing similar HOA overreach. They asked if I would consult with them on their rights. I agreed immediately. This fight was never just about my garden. It was about standing up to those who abuse rules meant to protect communities. As I sit on my garden bench, watching butterflies land on the flowers I planted 15 years ago, I feel a deep satisfaction. Not just because I kept my land, but because in doing so, I helped free my neighbors from petty tyranny. If there's one lesson from all this, it's simple. Never underestimate a gardener who knows how to read the fine print. If you enjoyed watching Karen and her power-hungry HOA get exactly what they deserved, make sure to subscribe to Neighbor Warfare. We share amazing true accounts of justice being served against those who abuse their authority. Have you ever dealt with unreasonable HOA demands or neighborhood tyrants throwing their weight around? Share your experience in the comments below. Was there a particular moment in this story that made you cheer? Let us know. And if you believe Karen got the perfect karma she deserved, type "Justice Served" in the comments section. Don't forget to hit that notification bell so you never miss our weekly uploads featuring everyday heroes standing up to injustice. From HOA nightmares to workplace revenge, we cover the most satisfying stories of people fighting back against unfairness and winning. See you in our next incredible true story.